City Hall, and thank you for coming tonight and learning more about Section 35s. We're joined tonight, we couldn't be happier and more thankful to have Judge Christopher Lecanto here tonight to talk about Section 35, and our good friend who's been a local person for many, many years, Clerk Magistrate Carol Vittorioso. So let's hope this is a great experience for you and you learn a great deal. Thank you.
Thank you.
Take it away,
Mayor.
guys.
Thank you.
Thank you so much. So Judge Lecanto has the top billing here, and I'm his warm-up act, so I'll start, then he'll take over from there. So as the mayor told you, I'm Carol Vittorioso, the clerk magistrate of the Fitchburg District Court. The first thing I would like to tell you is Fitchburg District Court is open to the public for anyone. Come into the clerk's office Monday through Friday, 8:30 to 4:30, with any questions, concerns that you have. The staff is excellent. We'll help you out with anything beyond Section 35 petitions. So I just want you to know that we're always open for you during those times, Monday through Friday. We're happy to help. So when we call something a Section 35 petition, it's called that because under the Mass General Laws, it's located under Mass General Law, Chapter 123, and Section 35 of the Mass General Laws Statute of Massachusetts. And petition is a civil proceeding for persons with an addiction, and it allows for an involuntary commitment to a treatment facility for up to 90 days of an individual who we would call the respondent, and the person who's filing the petition is called the petitioner. And the respondent is someone who has an addiction to alcohol or legal or illegal drugs, and that person must present an imminent likelihood of serious harm to themselves or others due to that addiction. Judge Lecanto will elaborate on that. There's a select number of people who can act as the petitioner. And when you come into the clerk's office, as the petitioner, if you have a concern about somebody who you think has a substance abuse issue and could cause an imminent harm to themselves or somebody else, you'd come in, ask for the staff member who's in charge of mental health petitions. They're very knowledgeable, well-versed in it. They cannot give legal advice, but they can certainly help you with the application process. But in order to be able to file a petition, you must be a blood relative, a spouse, a police officer, a court official, a physician, or a guardian. It cannot be yourself. It cannot be a girlfriend, boyfriend, or significant other. It actually has to be a legal spouse. It cannot be a therapist or a social worker, a friend, a neighbor, landlord, representative payee, or a concerned citizen. So what we do in the clerk's office when you approach, that's the first question we ask. If you do not meet that criteria, we try not to send you away. We'll ask you more questions to see if you could, are you friends with their brother? Do you know their brother as he is concerned? Do you know the person's spouse? We will actually try to help you rather than send you away and just say, nope, you don't meet the criteria. One time, I'll give you an example, we did accept a petition from a woman who I had never heard of this. It wasn't her spouse per se under the eyes of the law of Massachusetts, but she was considered a legal domestic partner and actually had a certificate saying so. And I wasn't quite certain. The staff came to me and asked. I didn't want to send her away for that. I was concerned about that, but she seemed very distraught, so we brought her before the judge. He, in fact, did issue it, but then we later determined that she did not have standing or qualify for that because she was considered a legal domestic partner. Frankly, in my own opinion, individually, do I agree with that? I don't, but the law is the law. It has to be a legal spouse in the eyes of Massachusetts.
Can I just jump in
Yes,
here one
please.
quick second? All right. So, and we can talk more about this, but oftentimes people have had other court involvement, and they may have a probation officer or a former probation officer. That person can also petition. So, if there isn't a blood relative necessarily nearby, but known to the probation department and known to, then the probation department can also file. Also, a police officer can file. Oftentimes, we've seen individuals who are either in traffic, in sort of inebriated and sort of a recurring theme, and the police officer has filed petitions in the past. The other thing, so COVID was a tough thing, no question about it. But the one thing that it did give us was Zoom and the capacity to have people Zoom in. So oftentimes a blood relative may not be in the geographical area, but they can Zoom in, be sworn in, and do the petition that way. So we're trying to make it as easy as possible. So there's lots of options, especially in the era of Zoom.
Thanks, Judge. That was good. And that's under the, obviously, a probation officer would be considered under the qualification of a court official. So after you've come in and you fill out the paperwork, and it consists of, I believe it's in your handout, it's an affidavit where you have to explain what the addiction is, what the concern is, how often you see the person, how do you know the person, the frequency of use of the substance, and then you have to give a detailed explanation as to how you believe the person is a danger to themselves or others. We also ask if there's a history of mental health or substance abuse commitments in the past, and also any other information you believe would be helpful to the court. You also will complete the petition itself for commitment, which, again, the reasons why you believe the individual should be apprehended by way of a warrant and not summoned in. You obviously sign it, date it, print it, put your information on there as well, and your phone number, and because when the individual in the police department does actually apprehends the respondent, the forensic psychologist will want to contact the petitioner and get additional information at that time before the hearing. I believe there's one other form. What am I forgetting, Judge? And then it's the respondent information form. You give as much information as you can about the respondent, and it's pretty self-explanatory. You just fill in all the blanks, and if you actually know where the person is at that time, that's extremely helpful for the police department. We'll, when we fax the information over to the police department, which includes the warrant of apprehension, we'll let them know where that person, where we believe the person was at the last time you saw them, and they'll go directly there. So then the staff member at my office will review everything. If they find everything to be in order, they'll docket it, which means we'll give it a docket number. So for example, this is 2022, it'll be 2022. Our district court code is 16, MH for mental health, and whatever the next petition would be. If it was January 2nd you came in, it would probably be 0001. It all gets docketed. They'll notify me that it was filed. Say this happens at 3 o'clock in the afternoon. I'll go and let Judge Locanto know, whoever the judge is at the time, that we have a mental health petition, and the person, as Judge Locanto said, we'll tell them if they've completed all the paperwork and had it faxed over and they're at home, we'll give them the Zoom information. They can Zoom in. We'll tell them Zoom in at 3:15. They'll come right in and they'll have the hearing with the judge at that time, or they can certainly come in person as well. They come, regardless of whether it's via Zoom or in person. The sessions clerk or one of my assistant clerks, or even myself, if we're running the session, will swear the person in, and then Judge Locanto will review everything, and then he'll ask them questions at that time to elaborate on the determination. I'll have him take it over from here. The other thing I wanted you to know is not only are we open from 8:30 to 4:30, but when it comes to civil restraining orders and any mental health matters, if we have jurisdiction over those matters, which means, in my opinion, you could go to any district court. In Fitchburg District Court, if you came in and you live in Gardner and you think that the respondent is going to be in Worcester, we will take it. we're not going to send you to the Gardner District Court, because we're concerned by the time you get to the Gardner District Court, this person could be somewhere else, or worse, no longer available for treatment or help. So we will take that person regardless of where they're living at that time. I think that's all I have for now, Judge.
Okay, so just a couple of quick things. It's traumatic to come into court, and we recognize that. And especially when you're coming in, when you have a loved one or a family member who's in distress. So oftentimes people will say, the person will be mad at me, or this is the, or it's really going to affect my relationship with this person, or, you know, this person's going to, you know, this person's going to be upset. Well, we're going to try to make it as easy as possible, first of all, and try to, oftentimes when someone files a Section 35, there'll be a lot of personal information, and I'll read it, and I'll simply say, is everything in here true? Rather than have the person detail, because everything's open to the public, but rather than have anyone detail, is this information true? Rather than have the person recite it out loud, which try to make it easy. The other thing, too, is these warrants of apprehension are good from 8:30 to 4:30. So as long as the court is open, they are good, and they're good for 5 business days. So if you file on a Thursday, 5 business days from there. We will take the petition, obviously, at any point up until 4:30 and conduct a hearing. But because it doesn't expire, but they can't, it's a daytime warrant, the warrants of apprehension. So as soon as you get it to us, and these cases are a priority in terms of calling in the courtroom. So if we've got a stack and the mental health folders are green in the court, one comes in, we're going to call that as soon as possible. Because the sooner that we have the hearing, get it to the clerk's office and send it out, then we've got, 5 or 6 hours before the end of the day, we can try to pick the person up that day. So we will take it up until 4:30, but obviously the sooner you get it to us in the day, the more likely is that it will be served that day. So when you come into court, you're coming into the courtroom, and it is an emotional thing, and lots of times people will break down, and we understand that. So it's sort of a last resort. I don't mean a last resort, because nobody wants to be in a position to petition against someone to have them picked up, but because of their substance use or alcohol use disorder, it's become necessary. So we'll go through the affidavit. I'll just say, is everything true? And then the one question that I have to ask that is, I always feel self-conscious about asking is, do you think the person will come in on their own if I don't issue this warrant? And sometimes people will say, yeah, he's in the car, or he's right here now, or let's, and sometimes that happens. And obviously when that does happen, then it sort of expedites the process. Usually, we will take the individual downstairs into custody. Here's why. And I know people get upset sometimes when they see their loved one being led downstairs. Oftentimes people will say, I'll volunteer to go, and then they'll want to use one last time. And they'll change their mind, and they'll leave. And so you don't want it to be one last time, because it may literally be the last time. So we bring them downstairs. We appoint counsel. The lawyer speaks to them. I always say to people when they file a petition, you're going to get a phone call from a number that you don't recognize. That's going to be the forensic examiner, because they're going to want as much information from the petitioner as possible. When did you last see them use? Is there any evidence of recent overdose? Can you tell me what their behavior's like? Have they had suicidal ideations? Do they become violent when they drink? Are there incidents of, say, domestic violence as a result of the consumption of alcohol? So the petitioner is going to want all that information. The other thing, too, is it may all well be in the petition, but the petitioner telling the examiner that sometimes has more of an effect. So you want to give the examiners as much detail as possible. Then we'll have a hearing in terms of in the open court, and we'll have to, and I'll go over exactly what needs to be shown, but one of the things that we need to touch on is this. So Carol had mentioned that if you file it here, but the person's in air, but the person's, oftentimes it'll be, the person's over at Leominster Hospital, and they're about to be discharged, and we want to file this petition here. So it'll be filed in Fitchburg. We'll send it over to Leominster, and Leominster will pick the person up, because Leominster Hospital's in Leominster. And so we're not going to send you all over the state in terms of having to file. We can transfer a Section 35. So if the person's in Worcester, if the person's in Boston, if the person's wherever, we can transfer it to that court without making you go to that area. When we have the hearing, the petition, sometimes people will talk to the examiner, sometimes they won't. Either way, we have to make a determination. The examiner will then testify. And so what needs to be proved, and this becomes difficult sometimes, is that the person suffers from an alcohol or substance use disorder. They've lost the ability to control their addiction, things like that. And then they also have to prove that they're in imminent risk of danger, either to themselves or to others. It's the imminent part, oftentimes, that becomes difficult, because using substance long-term is bad for you, right? But that's not enough. It has to be that there's an imminent risk. Obviously, testimony or evidence of recent overdoses, driving under the influence, accidents, things like that. And then we'll go through that. The other thing, too, is there are things, the statute changed, and we never would consider because people would oftentimes come in and say, Judge, he's willing to go to a program now. But I have to consider that now when someone comes in. My question always was, well, if they would consider treatment, why does it have to come to this? But I do have to consider if there's a less restrictive alternative. And so those are some of the things. Oftentimes, there is not a less restrictive alternative, where the individual will have been in treatment but keeps leaving treatment early. And then you say, well, is that really appropriate, given that this person has left treatment on a number of different occasions? And so those are some of the considerations that go into it. I can consider a number of things. The person's criminal history, if they've got history of substance abuse. Consider the testimony of the forensic examiner. And then oftentimes, if the person's in court and the examiner hasn't quite given me enough information, then I will ask the petitioner, ma'am, can you come up? Or, sir, can you come up? Would you mind taking an oath? And I'll start asking that person, well, what are you worried about? What have you seen in terms of the behavior? What can you tell me? And oftentimes, the individual will give me a lot more information than they've given the examiner, and sometimes it's because either the examiner didn't think to ask the question, or the person didn't think to provide that information when they were first asked. So, any questions at all? Go ahead.
When you say blood relative, how far does that extend out?
Usually brother, sister,
Mostly immediate family?
well,
Or if it's a cousin?
blood relative.
Okay.
Can I bring up one thing, Judge? So this is the way I see Section 5 petitions, there are two parts. One is actually getting petitioning for the warrant of apprehension. And then the second part is the hearing if the warrant of apprehension is issued. So I just wanted to bring up if.
And the person is picked up.
And the person is picked up and then brought. He has to be, and during those hours that Judge Lecanto discussed. But I also want to give the police department an opportunity to find out so you understand what happens on their end. So if Judge Lecanto issues the warrant of apprehension, he hears from the petitioner, it comes back into the courtroom, the warrant is, he signs it, my staff faxes it over to the police department. Sometimes it's hand-delivered. If we just did that last week.
Yeah.
Our sessions clerk sent one over because there was a sense of more urgency than usual there. So I'm hoping Officer Howe can tell you what happens, and I'm curious to know what happens. They're going to go, Fitchburg District Court's bothering us again, but.
Perfect. First off, thank you for having me. Thank you, Madam Clerk, Judge Loconto, and thank you, the Board of Health, for having this event. It is a good event to have to discuss the Section 35 process. From a police perspective, one thing I want everybody to know is what we see sometimes is if like a stepbrother or stepsister wants to apply for Section 35, theoretically, they're not a blood relative, unless I'm wrong, so they won't be covered. So that's why a police officer has the authority to help out with the Section 35. And also, as a police department, we are aware that sometimes when a person is trying to obtain a Section 35, that's their first time, going into a courthouse. Sometimes the people that we're looking to, for lack of a better word, I'm going to call it a civil arrest or an arrest. It's the first time that person is dealing with a police officer. So we understand how traumatic it can be, and I can assure everybody here that our police department is highly trained in dealing with any type of mental health issues or crises involving substance abuse or alcohol abuse. We will take as long as it needs to take to bring someone into the court. So we're not going to rush the situation. We have plenty of time. We want to do it safely when we do approach someone. The reasons why the person, so theoretically, when we get a summons, Section 35 sent to the courthouse, sent from the courthouse to the police department, we have to go out and arrest that person. And I don't even like using the word arrest, but unfortunately, that's what it is. So we'll find the person, we'll talk to the person and say, listen, we have to bring you to the courthouse because ABC. We have to handcuff the person.
Can I interrupt you here for
Yes,
just
you
one
can,
second?
Judge.
It's not on anyone's criminal record, just so you understand. Like, sometimes people will say, if I petition, will that give this person a record? The answer is no. It's a civil commitment.
It's civil.
There may be some collateral consequences in terms of, can the person have a firearm for a period of time? That's a different issue. But you're not giving someone a criminal record by filing a petition.
Yeah, so we'll handcuff the person. The reason we handcuff the person is we have to do it for the safety of that person we're dealing with, and also for the safety of the police officer, and then the safety of the court when we bring that person to the court. Because when people are abusing substances or whatnot, they may have weapons on them, they may have drugs on them. So we have to, the reason we bring them to the police station is we have to search that person. So we search the person for drugs and or weapons at the police station. Once we do the booking process, we obtain the name. We have to get certain information when we're booking the person. And we also check, which is important, we have to make sure there's no medical issues going on, because we want to make sure we get the person medical attention if the person needs it, because that's obviously priority. So we review the medical status of the person, and then we make sure the person doesn't have any weapons, and we do it very compassionately. We take our time. We don't rush, and we treat the person with respect. And then we immediately bring that person, if he doesn't, him or her do not go into our cell at the station, we immediately transport the person to the court. And then the court takes over from there. But what I want to mention too is, if anybody ever needs any help in obtaining the Section 35, the police department's available. Like, I can't tell you how many times I've walked people over to the court. I picked people up at their houses, I drove them to the court, and I'll get them into the court and help them with the process. We do it all the time, and that's a service we provide. If anybody ever needs that, all they have to do is call the police station and ask for the officer in charge, and then the officer in charge can arrange it to get that person help them. We do it quite frequently, because we're there to help.
Yeah, yes, you have a question?
My name is Rebecca. I work at Open Sky Community Services, and I'm curious if the police department would work with like a community provider who's funded by the Department of Mental Health to do a Section 35 if the police officer can do it, but I can't as a licensed social worker.
Well, if we have an interaction with the person where we can document, a lot of times what we do is we dealt with the person many times, and the police officers write reports. So what I'll do is I'll review the reports, and then if I see a certain pattern going on, and then if something arises to the level where the person's in immediate danger to himself, I could do the petition, I would go to the court, give it to the clerk, and then the judge would review it and go from there. But we could, depending on the circumstances, yes, we could.
Okay, so in that instance, would the forensic psychologist be able to take like information from me as the social worker in the community, or would it just be the information from the police?
So we've often had forensic people speak not only to the petitioner, but other family, anyone who can provide information as to why the person is a danger to themselves or to others, and as to why the person is suffering from a substance use or alcohol use disorder. Most times, the issue isn't whether or not the person has a substance use or alcohol use disorder. Most time, the issue is the harm imminent? Is the risk of harm imminent? And those are tough cases, and I'll tell you why. So, first of all, if the police bring someone to court anytime before 4:30, and I mean 4:29, we're staying until that gets done. So, we've been there 7:30, 8 o'clock. This is the business we're in. We're in the business of helping people. So we're not going to say, oh, it's 4:30, see you later. But we can't pick up anyone after 4:30, if that makes any sense. I'm sorry, your question was, let me touch on this topic. There are times when someone will file a petition and there isn't enough information that the risk is imminent, and the petition will be denied. And I always say to people, number one, please don't get discouraged. Number two, please don't give up. And number three, please understand that the courthouse doors are always open to you. Please come in any other time. The other situation is this. We've often seen people come in on a Section 35. The commitment, by the way, is for 90 days. But I can tell you as a practical matter that they're keeping these people anywhere between, say, 25 and 30 days. And that's how long, and I know everybody, because you're all in the treatment field, right? 30 days is not enough. The whole purpose of the statute is sort of it's imminent, we need to stop it now. And then what is supposed to happen is when they get discharged from the facility, they have a discharge plan. And the discharge plan includes any number of different things. There are facilities like, say, Stony Brook, where the person may leave with a prescription, or and they'll give sort of a bridge prescription so that the person leaves with some medication if there's a medical assisted treatment issue with respect to that. Sometimes one commitment, we don't see the folks again, and I like to think, although I'm not naive enough to think, that means the problem is solved, right? And then we've seen some people, and people will say, we did the commitment, he was good for 6 months, or she was good for 6 months, and then now we're back here. It's like, please don't ever feel like you're bothering us, or that there's a limit on the number of times you can file, or sometimes there'll be different family members, so the petition will be for different family members. That's perfectly okay. So please, no one's upset, no one's mad, no one's not happy to see you. So however many times it takes, please come in and see us, whether it's multiple petitions on the same person or different petitions. This is what we're here to do.
I just want to make a statement. My name is
Sure.
John Como.
Yep.
Sometimes, if you try to get 35, a statement from that one loved one alone is probably going to get thrown out. You got to get all your ducks in a row if you're going in that direction. If you know a police officer saw them inebriated or Narcan, talk to the police officer, get that statement. If you have another family member that's seen some things happen, seen them fall down drunk or whatever, the court can take a statement from that family member, or even call them and talk to them. It's a difficult process to pass a 35. It's not, I'm going to write this out, I'm going to go to the courthouse and we'll be good. It's not that easy. you need to have, you need to have seen the person using recently. If you have a loved one and they're gone, they're living on the streets, you haven't seen them use in a while. You know they're using, they call, they're sleeping in places wherever, they're doing things, you know they're doing bad things, but you haven't seen it. Well, when's the last time you saw them use? Well, it's been a couple of weeks. It's not going to pass. You need to get different people together, get your information together, because I've seen some pretty solid ones get tossed. Suicide note, somebody using the Narcan, wrecked cars, lost jobs. Oh, we're not going to do a 35 on them. Make sure you have all your information together before you go and try and get a 35. It's difficult. It's not an easy thing.
Yeah, like he's saying, just a good example, let's say there's a person that keeps drinking excessively, and let's say that person keeps falling asleep with the stove on because he's drinking too much. That's the stuff you want to put in there. Or he's going to bed with a candle lit near the bed because he's inebriated or she's inebriated. So anything like that where you want to bring in the imminent danger part, put stuff like that in there.
But I just want to say this. I don't know that I agree with everything that he said. I'll say this. Bring in all the information that you have, okay? I would rather have you file the petition and go through the hearing and pick the person up and try to get as much information as possible than for you to be discouraged and say, I'm not going to file it, because I'd rather have you file it than not file it. And it's not a bother. Go ahead, I'm sorry.
If it's filed and it's, I don't know what the word is, but dismissed or whatnot, you don't approve of the section 35. It's
So you
still
deny the petition? Yep.
If you deny the petition,
Yep.
is it still on file at the courthouse? So let's
Yes.
say if somebody files again.
Mhm.
Okay.
Yes.
So what I run into a lot is that somebody's provider, either there's a lack of providers in the community, they won't file for a section 12. But if I have police intervention, like what we're talking about, and the police might be able to do a 35. Because sometimes the providers will say, well, this is a substance use issue, it's not a mental health issue, even though we're going back and forth saying it's both. So it's kind of, sometimes I feel stuck as a provider, like, do I work for a 35, not being a family member, or do I work for the section, the provider's saying, we're not gonna do the section 12, so I kind of get stuck.
Well, so there's a lot of stuff in that question. Okay.
This is
So,
my life.
yeah, no, listen, what we all know is this, right? Substance abuse is hard. And so we have a drug court in Fitchburg, and some of the people who, they do well, but, the program itself is 18 months, and recovery is a lifelong process, right? So Section 12 is emergency mental health. Section 35 is substance use or alcohol use disorder. So Section 12 is limited, though, because Section 12 is a 3-day commitment. Section 35 is a 90-day commitment.
So when I file the 12, it just gets into the ER for the eval.
Right.
And if the eval says no.
Well, so what ends up happening is, in that type of Section 12, it's what's called a pink slip. And it goes to the hospital, it goes to the emergency room. And so it's not an effective mechanism to deal long-term with substance. But if the person is having a mental health crisis, then it is an effective tool. But it's different, and different people can file the Section 12 than can file the Section 35. The issue with the Section 12, though, is it's not transferable to another court, so that, like a 35 I can send anywhere in the Commonwealth. A Section 12, I can't. I will say this, the more information that you have is helpful. One of the things that I consider is prior petitions that have been filed, because what will happen is the clerk's office, if there have been prior petitions that have been filed, will bring in that folder, whether they're allowed or not, and I'll be able to review, and sometimes you'll see a progression in terms of someone's substance use or risk of harm, and then it makes it, I don't want to say easier, but it's more information. The more information we have, the better. In terms of, there are times, well, when's the last time you've seen this? Well, I haven't seen him in a year, right? but those are so rare. Usually it's, you know, my son has lost, or daughter, have lost their children, have lost their job, have, you know, we've had to call the police 3 times in the last month because they've been unresponsive. And Section 35, and then the person's brought in. So it all depends. The other thing, too, is I don't necessarily agree with how imminent the risk of harm is. But I'm also a judge, so I have to follow the law. But, you know, imminent is in the eye of the beholder, and there are times when the person will come in and, you know, you look at the person and they're in really, really tough shape. You know, in those situations, I probably will find more imminent than not imminent, even though I'm not supposed to say that. But no, because you know, look, you know, you're trying to save the person's life, and then the other thing too is this: I know that the 28 days, or even if it was a 90-day, isn't going to fix the problem, but it's going to put a break in the cycle right there. The always worry is that when someone stops using for a period of time, then if they go out and use the exact same amount that they were using before they went in, that is a risk. I mean, there's no other way to say that. But it's not a situation where 35 does more harm than good. It doesn't. It does a lot of good. And it sometimes is the first step for recovery. And I know a lot of times, like we talked about, that family members are sometimes worried that their family member will be mad at them or won't speak to them again. That's usually not my experience. The family member understands that this is, you know, obviously mom and dad, this is the last place mom and dad want to be. You'd be amazed that the residual negative feelings, they really aren't. Sure.
When you say it's kind of that last option, right? So if you have someone who's willing to go right now and they can go to detox or they can be sectioned,
Yeah.
how do you make the determination of whether they go to a detox or
Oh, so whether or not to let them go to a less restrictive condition? I at least have to consider it. That never used to be the case, but it has been, I think, the last 5 years, I think. If the person has a history of leaving programs, then I'm probably not going to find that to be, or if the program is inadequate. The one thing that I do have to tell you, though, is most Section 35 facilities are not locked. Okay? So I don't want to give you the impression that it's a jail setting, because most of them are not locked, and we have a number of individuals, not a number, because most people will stay, but some people leave. They'll somehow finagle a ride, they'll, and, you know, they get a phone call somehow, and then they'll leave the facility. And that, so it's not an escape, because it's this is all technical, it's an elopement, not in the marriage sense, it's an elopement, and then, you know, you try to re-pick that person up. And then we're supposed to get notified when someone elopes from a facility, and then oftentimes people come in and ask for another petition. The other thing too is sometimes, despite the best efforts, the person will not be picked up in 5 days. Please come back, and oftentimes they'll copy the petition, and I'll just sign it and to try to extend it. Yes?
French, street outreach worker. So say you have someone who is homeless and you file a section on them, and the police officers can't find them because, you know, disappearing or whatever.
Some people are good at hiding.
Yes.
Okay.
So how long does the section, like the daytime warrant last? Is there an?
Oh, 5 days.
5 days.
5 days. And that's what I mean. So if at the end of 5 days the person isn't picked up, come back. All right? Because the clerk's office, and I don't know this, you're probably not going to have to write out the petition again. They'll probably make a photocopy of it, unless there's additional information that you can add to it, and then you can add to it. But, and then I'll allow the petition again.
And I can add, if the courts did authorize a Section 35 through the Fitchburg District Court, and then you as a family member or loved one calls us and says, listen, he's at ABC Street in Boston, Massachusetts, we will contact the Boston Mass Police, and we will have that person, picked up by Boston. So no matter where the person is, if you let us know where that person is, we can get the service, or we can get the person some help.
I'm going back to your point about how, and I don't know what you did with this case, but how often or how recent a loved one may have seen the respondent to which they want to file a petition. I recall within the last year, we had a gentleman email us. I don't think he was in Fitchburg, but I don't know why he contacted the Fitchburg District Court. Oh, because he knew he had an outstanding warrant in Fitchburg, and he hadn't seen his brother in months, but he was getting phone calls from people who knew his brother, who was in the Boston area, living under bridges, living outdoors, was homeless, and knew they had a substance abuse problem. So he reached out to us via email to say this is the information he received. I believe he filed a petition. I don't recall what, I guess we need more information, but we do get, sometimes those situations do happen where a loved one who was qualified to file the petition may not have seen them, but gets information from other people that this is where your loved one has been and this is what's been happening, so.
So this is one of those situations, in court where you hear the word hearsay. You say you can't do it right, you can't, well, you can in a Section 35 petition. I can consider hearsay. So as long as it's reliable. And reliable, again, that's one of those things where if it's detailed, if it's provided by a disinterested person or even an interested person, but someone who says, I talked to his girlfriend and this is what's going on, oftentimes that information will be considered. The other, just one second. The other thing too is, so these, if I commit someone, they can appeal the commitment, but I just want to say this, the person still goes to the commitment. And sometimes by the time the appeal gets processed, most of the commitment is done. So they don't dock my pay if I get appealed for something like that. So. No, I know, and these are some of those cases where you want to be safe. You'd rather be safe than sorry, but sometimes there just is not enough information, and it's always heartbreaking. It's heartbreaking to hear the petition. It's heartbreaking when the person comes in and you see that they're in terrible shape, and and it's really difficult from a judge's point of view, to deny when you don't have enough information. Because that the folks are coming in and they have all the best of intentions in the world, but there just isn't enough information. So, go ahead, sir, you had a question.
I do wish I had gone in front of you a couple of times as I tried this. I've gone through this with my family, and it's actually working out. Typically, if a loved one gets into a 30-35 program, they end up loving you once their head is clear. They know you did it for the right reasons. The only reason I brought that up is it was not this court district, well, it was Worcester. And I did have a situation where we did have a suicide note.
Mm-hmm.
We had the sheriffs with us. We had a sponsor with us, both parents. Everything was together. And we brought in the section. And we actually cleaned her apartment out. We started cleaning it out. She was back in 6 hours.
So, here's the thing. So you can always find a story where someone has had a negative, and I'm sorry that you had a negative experience, by the way. No, it's okay, well, not everyone feels that way, but, no, but what we try to, especially in these sort of situations, is it's traumatic. And so, like, I've spent basically every day of the last 30 years in a courtroom, right? And so sometimes when you're there all the time, you become desensitized to the whole court process. But these are the situations where you really have to slow down the court process for the people who are filing and just say, okay, because a lot of times they'll, before COVID, and I'm going to start doing it again, but I used to have the people come up to the bench. and just say, because it's traumatic, just come up, like, stand right there and just, okay, tell me what's going on. And then we'd have a conversation. All right, the petition's allowed. And then they'd go issue the warrant of apprehension. Because making someone, like from that glass to here is where the bench to the rail is. And to try to explain that, it's very difficult. So you try to minimize the stress of all that. But no, I'm sorry that you had a negative experience.
It worked out in the
Good.
end, but it was difficult to bring together. We actually went in, my daughter has to go to school, she's one section, but it took 4 people, the sheriff's office, once again, that knew, and met her and talked to her. The head of the shelter that she was staying in, the sponsor, both parents, and they were gonna say no. The only reason they didn't say no is her sponsor stood up and blasted them. They said, if she leaves here and dies, this is on you.
Yeah, so, among all the things I shouldn't say, I mean, that's crazy to me that you had all that information, and it doesn't sound like it was a close call.
Not you.
Okay.
It was just a different courthouse. I guess everybody thinks a little differently. Even if it fails, maybe next time we try to go to a different courthouse, because different people think differently.
Well,
Good.
I just wanted to add one thing is that when this person comes to court, he is going to have an attorney assigned to him, so he's not going to be there without representation.
I will say this too. There are times when the person realizes that, you know what, I'm gonna go. I can't do this anymore. And that happens more often than you realize. Once the person is in there and they say, yeah, I can't do this. I agree to go. And they'll go. And, sometimes it's a good attorney who says, attorneys have different roles, and sometimes it is in their best interest to be committed. And sometimes after a conversation with the lawyer and the examiner, they'll say, yeah, I will go. And oftentimes they will go. How are you doing? Good.
I'm James Cunningham, if anybody doesn't know me. But how many different facilities do they have now that they can send you to?
Many.
So I know before it was, they'd send you to...
It used to be like, Brockton or...
They'd send you to Bridgewater, and you'd be in there with a bunch of, in the wrong place, and also...
Yeah, so no, the treatment facilities are treatment facilities. So Stony Brook is a locked facility. And so, for instance, there are times when someone will be on bail, but they also have a substance use disorder, and they're in need of treatment. And so I've ordered commitments there, and then that's a locked facility, so the person...
So it's like Massac and Brockton there? Whereas it's a locked door, but you can, if you go to leave, they will.
No.
They will let you out. They'll open the door and they'll let you go. They're not gonna...
No, it's a locked facility. Stony Brook's a locked facility. There's one other locked facility. So Plymouth, and so yeah, so what ends up happening is there's never enough beds. And you know that because the commitment is for 90 days, but they only keep them for about 4 weeks. And, you had the idea that if we could keep folks longer and we had enough beds, that the period of detention would be a little bit longer. But sometimes the 28 days is a good start. Go ahead.
Do you determine which facility they go to?
No, so what ends up happening is the doctor will call and find a bed. Yeah.
So, some places you need Mass Health, like,
No, they're not a function of insurance. Doesn't matter if you're uninsured, you're not paying for this. Yeah, no. This isn't an insurance thing. This is it's a civil commitment, involuntary commitment by the court. So they're not gonna send you a bill, they're not gonna charge you Mass Health. That's the cost of the bed. So, go ahead.
Couple questions.
Sure.
One is, are there safeguards to prevent Because, I mean, you have the right to make bad decisions, but when that bad decision becomes dangerous, so are there safeguards that, like, this doesn't get abused? And then my other question was, what kind of treatment do they actually receive? I mean, is it recovery? I mean, just kind of describe the day in the life of somebody who has to, go, but
So,
two very different questions.
so you want to know, is there something in place so that someone just doesn't keep getting committed as an abuse?
Yeah.
Okay. The safeguard, frankly, is that you have the right to be represented by a lawyer. The burden of proof is by clear and convincing evidence, which is not quite beyond a reasonable doubt, but it's by clear and convincing evidence, so it's a high burden of proof. And it's, so, yeah, but, right, the petition has to be found by clear and convincing evidence that the person not only is suffers from a substance use disorder or an alcohol use disorder, but they're in imminent risk of harm. So, I don't really see that in the sense of, I don't see a lot of abuse of that, because when you see people come in multiple times, it's not because, I really want to, cause this person problems, or, well, we're getting a divorce, so, I really want them, like, I don't really see that. I see it's, the family's desperate.
It's very, very, very rare for us to petition the court for a Section 35 when a person doesn't have a family member also. Very rare. I can count in my 29 years, I can count in my hand how many times. So it's not something we're out there actively doing. We're usually helping a family member with the process, so.
A lot of times, like, anybody can walk into the courthouse, and if you're looking for help, like they say, you can section yourself, but you can go in there asking for help and appeal, or somebody they'll help you. As long as you're looking for help, they'll help you, so you can go in there and basically section yourself, even though the PO will do it, or somebody else from the court officer, somebody will do it for you. So,
Yeah. The other thing, too, is there are a lot of great resources in this community. And it's funny, you've seen the evolution, the progression of how many more programs and how much more help there is available for people in the North Worcester County area. And so if you have someone who suffers from a substance use or an alcohol use disorder, there are a number of people who will help, and a number of people who can guide you and point you in the right direction. That's not to say that this is one of those problems that's only going to be solved when everyone from the community gets involved. And so we have great resources, and people should use those. One of the resources in the community is the court. So, and I'd say we have, and there's a probation officer here, and I'm not just saying this because she's here. No, we have a great staff over at the courthouse, and we have and we have very experienced probation officers, very caring probation officers, all of them. And so, whether or not there's a Section 35, are you aware of any program? Use it as a finding tool in terms of, is there a program available? Who can I call? What's a phone number, kind of thing. There's just some great programs here. There really is. And the good thing is, there's so many good programs. The good thing is, and I'm glad to see it, is that sort of the stigma of mental health and the stigma of substance abuse and alcohol use has really subsided. And we're not there, not 100% there yet, but it's moving in such a positive direction that getting help is not seen anymore as a weakness. Getting help means you need help, right? You don't be embarrassed about going to a doctor. Well, this is another form of treatment. And that's why we talk about doses in terms of probation or treatment or things like that. We think of it in doses because people can understand that. It's a dose of treatment. How many doses does it take? It obviously depends on the individual, but obviously And that's why the language, if you notice, has changed a lot. And it's in a much more positive and therapeutic way to discuss it.
John, do you like to talk about how probation use the treatment recommendation from section 35 and recommendation and violation of probation?
Yeah. So, like we say, when they come out of the program, they, so when someone's on probation, and if they were on a 35, then I'm not looking to be punitive to someone who's suffering from a substance use disorder, and they test positive, you know. Jail is generally not the answer, right? But when they come out with a treatment plan, oftentimes the probation department will adopt that as sort of a ever-evolving conditions of probation to really get the person some help. So any information is good. Usually any information is good information. You had a question over there, sir?
Yeah, somebody's committed under Section 35, they have warrants. Does that affect the length of their stay and also when they're released?
That's a great question. So if someone is, sometimes people will come in on a Section 35 and they'll have a warrant. And you know, usually what I'll do is I'll give them a notice of warrant recall. And so I'll have them report. So I'll make the notice, report to Worcester in a month, because I know that the first 28 days they're going to be in treatment. Because I don't want them taken out of a treatment bed because of a warrant. So I'll recall the warrant. If it's a violent offense or a like something out of the Superior Court, that's a little bit different. Usually that's not the case. Usually it's, you know, shoplifting, right? Disorderly person, things like that. I'll remove the warrant, have them show up later. Because when I have them show up later, 9 out of 10 times, they're showing up to court in a lot better condition than they were prior to the commitment. Sure.
In Fishburne, we recall the warrant. I had somebody that he had a warrant from probation from Fishburne, and he was in Air District Court, so they did not record the warrant, but they assumed from this place that I love it, Stony Brook facility, they assumed the judge removed his warrant.
Rather than take the person out of treatment.
We often get those originate in the clerk's office. Stony Brook or another facility will email us, say John Doe has been here, and he was here while his court was pending, and now as a result of that, there's a default warrant out for him. So that'll come to me, and I will tell the staff, let's schedule this for Wednesday, you know, April 20th, for them to Zoom in, give them the Zoom information, and I'll let Judge Lecanto know, remember, you know, John, this is where John Doe's been, and it's going to be on next week. So that is a very good question, because that happens often.
Yeah, a couple of other things with that is, so oftentimes people will be arrested, they'll be bailed over the weekend, but then they'll go to a treatment facility. All right, I'm only speaking for me now. I don't default people. They're in treatment, I'm just giving them a date.
Yeah. If we know in advance, certainly. Sometimes
The other
we
thing
just
too
don't.
is, because we'll get a letter, the person's been admitted to XYZ program, and we expect that person to be here until X date. Well, then I'm going to give them a date after that. Something else I wanted to say in terms of that. Oh, if you were in a treatment program and you were defaulted during that period of time, we didn't know, we'll expunge the default, because I don't want that to be held against you later on. Because we as judges will take a look at someone's record, you know, when they come before us, and the number of defaults is a factor in terms of bail and release and things like that. But if you were in a treatment, I'm going to expunge that warrant, so it's not ever going to be held against you either by myself or anyone else. Whoa, we've covered a lot of ground. What else? Do we have any other questions? Go ahead.
I'm sorry. I have somebody who is Narcan at one of my group homes, and while they're on their way to get medical treatment, we want to file for a Section 35. Somebody that the police knows very well, has been to the program a lot. how does that work? Like, if they're getting, like, let's say they go to UMass and they get some medical treatment, but we still want to move forward with the 35, like, how does the court do
There's
that?
a couple of different ways you can do it. So who's transporting them to and from UMass?
An ambulance.
Okay, that's a little
So
different.
let's say, yeah.
Okay,
I
so
have
let's say
somebody
someone
from-
from your program is transporting them, and someone has filed a petition, just bring them right to the court.
But I'm saying, we Narcan the person, our policy is to call 911.
Call 911, they go to the
They go
hospital.
to like Leominster Hospital.
Come to Fitchburg,
We
file
go
it.
to the courthouse.
Come to Fitchburg, file the petition. We'll send it to wherever the hospital is. No, but you said it's someone known to the police.
Right.
So the police file in Fitchburg, then the warrant of apprehension will go to the place where the hospital is, Leominster, Worcester, wherever that is.
What sort of burden of proof should we prepare for the police department if in that situation?
Yeah, basically, if you want to do a section, you would speak to an officer and you just present the facts. And then if the officer thinks he needs more information, the officer knows what to ask based on that certain circumstance, because, you know, we won't be able to cover every possible scenario. So that's why we're going to have a question and answer period back and forth, and we'll document. We might look at our in-house computer system. So it's basically a totality of the circumstances, and we'll just review everything with you, talk to you, and we'll write it down on the petition, and we'll get it over to the court and have the judge review it and go from there.
The other thing too is, so when someone is brought to a hospital because of an overdose, please don't assume that the probation's notified or that the court's notified, because oftentimes we don't know. So to the extent that you have that information and it's relevant, that should be brought to the attention. When the person's on probation, there's a ton of options in terms of getting some help. But obviously, we're here tonight to talk about Section 35.
We got the SORT report, and usually we call the police and we request why this person was in the SORT report. And a lot of time we get, we get information that the person had an overdose. We don't use that as a violation of probation. So we're just looking for help for that person.
Yeah, the big thing to, get the person help is have open dialogue and communication amongst all the parties involved, and we'll get something done. And like the judge said, I can't emphasize enough, if it doesn't work out the first time, don't quit, we'll keep plugging away. I can tell you, your police department is here for you. We're compassionate, we care, and we will do what it takes to get you help. So if you don't, feel free to, call us every day if you have to. That's what we're here for. And Chief Martineau, who's here on my right, which he was fortunate enough, he created the Community Engagement Unit, and part of that reason is because it frees up officers to deal with issues such as what we're talking about tonight, so we can provide a great service to our community. Because that frees up officers out of the patrol division to work on things like this, so.
Yo, sure.
Good evening, everybody. First of all, I'd like to thank the judge, Carol, for being here tonight. Lieutenant Howe, as he said, he's my right hand when it comes to everything we do in the city as far as engagement and outreach. As you can see this evening, there's a lot of passion. There's a lot of compassion between the district court, local law enforcement, and all the providers that are here tonight to really tackle this head on, and it's often said that, we're looking for tools to put in the tool chest. Let's keep in mind, Section 35 is just one tool. Section 12 is another tool. The unique thing with both 12s and 35s is the police play an important role in both of those. Right now, in the next month, the police department is hiring a full-time clinical support person to be embedded in the police department. I'm bringing on clinical support, a master's level clinician that will work full-time with my police officers, will be out in the street driving with our police officers. And as to what you said earlier, working with clinical support, we have the authority to 12 or petition for a Section 35. So closing that gap, that's just another tool to have.
Should we hire the clinician?
We're in the process right now. We're partnering with CHL. CHL is our healthcare provider. I anticipate within 4 weeks we will have that clinical support embedded. Using that clinical support in conjunction with what we do with crisis intervention, we're covering all the bases, and we're trying to make ourselves as available as to many people as possible. I gotta give kudos to the city of Fitchburg and the health department. They have really taken a proactive approach. We currently have 2 full-time outreach advocates working for us right now. We're working closely with them where we have the authority to do a 35 or talk about a 12. We work closely with Keith and his team on the homeless outreach. So the 35 we're speaking about tonight, that's just one tool. But the tools that we've encompassed here in the city of Fitchburg is second to none. And we're providing those resources to the people that, quite frankly, need it the most. So I just wanted to come up and say thank you for everybody coming out tonight, Judge.
Thank you, Chief.
And
Can I just add one thing about section 12? So on the Patient Act, that's like a transport paper, right? So they get to the
The pink
hospital,
slip.
and immediately, it's like they can sign a CV, they can get out with a 3-day. So, I mean, just keep that in mind when, if you're approaching.
So I'll say this, I don't love section 12. Okay? It's not the, it's like everything else. There are tools that work great, and there are tools that don't necessarily work as well as we would like them to. Because theoretically, they can go to the hospital, the doctor then can make further civil commitment petitions. It's a rare case, though. And oftentimes, you worry that the person's gonna go in, "Were you suicidal?" "No." "How are you feeling?" "I'm feeling great." "Okay, there's the door." And so, you worry about that. But it's like everything else. They do work sometimes. And so please don't give up on them. It's just, it's like every other solution. It's not perfect. But there are situations. The other thing too, in this community is we're so lucky because we do have great partners. We do have great people in the treatment community. But we also have great partners with Chief Martineau, with the mayor, with the sheriff's office, with the district attorney's office, in terms of whether it's the OCC, I know it's not OCC anymore, Community Justice Support Center. So they change the names to these things a lot. I think it's just to see if I'm paying attention or can remember the new name. But Community Justice Support System, Center. I know. And whether it's that or whether it's drug court, there is gonna be a graduation on May 4th. From the first one since the pandemic, of the folks over at it was OCC when we started. Okay, Community Justice Support Center. Never gonna remember that. And so there are so many avenues for treatment, and with or without court involvement.
You had brought up section 12. My officers do an abundance of section 12s every week. When I started as a young police officer 35 years ago, I never even saw a section 12. We just didn't do them 35 years ago.
And you know what else we didn't do? We didn't do 35. 35s were so rare. And, but it's, as you all know, I mean, I'm not telling you.
The average of
It's,
section 12, probably one a day,
Yeah.
7 in a week's time. And one thing I have to say about section 12, because you brought it up, it's a tool, but it's a crisis management tool, because a lot of times the police are called in the middle of this big crisis, and the only tool, because the last thing you want, we figured out a long time ago, you just can't rescue your way out of this problem.
right.
So 15 years ago, we go to this crisis, we'd slap cuffs on them, they were under arrest for a criminal charge, and then they go into this big, deep black hole of the criminal justice system where they don't belong. So now we use the section 12 as a tool to divert it from the criminal justice system. We have to do something. When law enforcement's called to a crisis, we have to take some type of action. So we do use section 12 quite a bit because it is a tool, but you're right. They go to the hospital, and a lot of times they're back in the community in 3 to 6 hours. But you got to look at it as this way. It's crisis management at its worst moment. And, that maybe that one case will get diverted at the hospital, and that's our hopes.
But I also know that if the person is a patient of the Department of Mental Health and they have history of mental health at the hospital, they are not going to release the person in 3 days.
Right.
They are going to place him in a facility to get the help.
The great thing about it, section 12 though, as the chief said, is there's a crisis now. And sometimes the 3 to 6 hours break sometimes makes all, and hopefully it's longer, but at least that makes all the difference in the world sometimes. It diffuses a bad situation. And the police are great with respect to this. They really are, so.
I just want one kudos to my police department. We have 83 police officers. 50 of my police officers have a higher level of training in crisis intervention. 100% of my department is trained in mental health, first aid, and first response. Also, all my 911 dispatchers have gone to mental health training. So when someone in crisis calls the police department and they're in crisis, my dispatchers are trained to communicate effectively with someone that's in crisis. Just another shout out to my department and the work that we do each and every day. So I've spoken up.
Thanks, Chief.
Thanks, Chief.
As somebody in the community who's worked with the Fitchburg Police Department, it's the only police department that will work with our agency, and they're phenomenal.
And I just wanted to let you know that the crime is very low here because yesterday we didn't have any arrest.
Just yesterday.
Yesterday I was the probation officer of the day, in charge of everything, and the first things that I said, how many arrests we got? None. So, that's great.
Sir.
Understanding that Section 12 and Section 35 are also very different tools.
Yes.
Is Section 12 not limited to like the 8:30 to 4:30? Can that be executed at any time of the day? Or is that slightly, like if somebody's admitted to the ER at like 11 at night and they need to be pink slipped, is that?
So,
or
but
how
so that's a little bit different.
Yeah.
If we're issuing the warrant of apprehension, then yes.
It's between 8:30,
But
that's when we're
you
open.
folks
So we do it, we would do it Section 12, and the judge would do a Section 12E, if I'm correct, right?
Right.
Judge? Okay.
Yeah, so it's a little bit different, because, the clinician can pink slip the person.
Basically, what Section 12 does for the police, it gives us the authority to get that person to the hospital. That's all it does. Against their will, they have to go to the hospital. And then the hospital will make the clinician at the hospital will determine from there once, whatever's gonna happen.
I just want to thank you. I really appreciate the fact, Judge, that you use recovery-friendly language. You don't call somebody an addict. You call them a person with an alcohol use disorder or a substance use disorder. I wish that there was so many other people that would use your example as a
Well,
judge.
thank you.
So I appreciate that.
So thank you.
I just wanted to plug one thing before we leave. On the family end of things, restoration recovery, me and my wife run a group called Families Coping with Addiction. It's on the first and third Monday of every month. It's where family members over the age of 18 can come and just discuss things freely, get support, anything that families need. Anybody over 18, it's Families Coping with Addiction. It's free. It's private. We'd like to see, if you know anybody that's just falling apart and needs help. We've been doing this for a while. Other places, but we've started our own group. So any families, just have them check on the Restoration Recovery's webpage and just get the dates when we're there.
Thank you. The other thing, I just want to say this to everyone here who's in the treatment community. Thank you, because you are saving lives and you are making a difference. And so the person comes to see me, and they're not in front of me for very long, but they're in your hands for a lot longer, and you are making a huge difference. And we are going to beat this. It's going to take all of us, but we're making good strides, and thank you all. All right. Thanks, guys.
Thank you, Judge.